This is the American Law Journal.
Maybe it's not President Obama or Harry Reid or John Boehner. Maybe the most powerful person in America is Justice Anthony Kennedy. Welcome to the American Law Journal, and tonight is the first Monday in October. It's the new Supreme Court term. How will these new cases that this court is going to hear impact all of our lives? And is this one of the most ideologically divided courts in recent memory? For a guest to weigh in on this topic tonight, let's go ahead and meet them. Mary Catherine Roper, and she's with the ACLU, the Philadelphia, Pennsylvania office. The Honorable Edward Kahn joins us once again. For decades, Judge Kahn sat on the Eastern District Federal Court. As a matter of fact, the federal courthouse in the Lehigh Valley today bears his name. Professor Michael Moreland joins us once again. Joined us last time in 2008, right before the last presidential election. He is a professor of law at Villanova School of Law. And Stephen Scheller joins us once again, not only a well-known personal injury attorney in Center City, Philadelphia, but also represented Al Gore in the butterfly ballot fiasco back in 2001. Let's take a quick look at our court. And here it is, Chief Justice Roberts at the very top. And then right below that, that top line, the so-called conservative end of the court. And below the line, we see the so-called liberal end of this Supreme Court. And I want to roll in a clip from last year's first Monday in October. And where this court sits, let's hear from Kelly Tillery.
I think we're heading towards the right for quite some time, and there are issues like Proposition 8 they're going to come up. There are issues like the Papers, Please case in Arizona. There's issues of Obamacare. There's issues of those sorts which are very fundamental to our nation, and they're going to be decided by the unelected Supreme Court in the near future, and they're probably going to be decided by the pivot, and that's Justice Kennedy. So one unelected man is going to decide some incredibly important issues.
Judge Kahn, is there any doubt that Justice Kennedy is indeed the pivot on this court?
He is the pivot on the court because he strides the line between conservative and liberal, and the court is pretty well divided with 4 conservative justices and the other 4 liberal, with Kennedy in the middle. And therefore, he is a significant justice. He will be a factor in the cases that are coming up this term.
He has been, and he will continue to be, of course. Mary Catherine, lots of folks say, with a Kennedy in the middle, that really bespeaks how conservative this court is.
Well, there's a lot that bespeaks how conservative this court is on many, many issues. It's not the first time that one person has, by any means, that one person has had an almost controlling seat on the court. For years, Justice O'Connor, with her rather narrowly crafted decisions, would decide a case, and the 4 on one end wouldn't like what she did, and the 4 on the other end wouldn't like what she did, but it was the only place in the middle that people could meet. And we see a lot of that, I think, with Justice Kennedy also. He is a justice who can get very emotional and very engaged in issues going either direction.
Well, my view is that I don't use the term conservative and liberal. I'm concerned that what's happened is a compromise has lost its way, and that you have 4 members of the court on and you call them conservative. In some respects they are conservative. I am conservative in many respects, but in others they just seem to be against the kinds of things that I thought this country is standing for. Respect for the rights of individuals, respect for the ability to gain access to the court system at a reasonable basis, and access to fair decisions that lead not just to protecting large businesses or corporations or moneyed interests, but the ordinary person. That, to me, by the way, is conservative, not liberal. That Justice Kennedy has to be the swing vote in those decisions saddens me immensely.
Mike Moreland, your position on this?
Well, I think there's a danger of overstating how divided the court is. I mean, 60% of cases are resolved 9-0 or 8-1. But in those cases that the court is deciding on a 5-4 or 6-3 basis, Justice Kennedy is almost always in the majority in those cases.
Yes, right. I think 20% of the cases last year were 5-4, which again begs the question, is this court ideologically driven. And this is what Catherine Langto, a colleague of Mike Moreland, said on last year's First Monday in October show. I think we're long past the day and age where a president is going to make a mistake. We're not going to see, as Eisenhower, appointed Brennan, or we saw that John Paul Stevens was appointed by Ford, or more recently, Bush 1 appointing David Souter. Those days are gone.
I don't think those were mistakes. I honestly think that something happens to people who have lifetime tenure. I happen to have lifetime tenure in a different job. But I think something happens when people find themselves on the Supreme Court, that they find that the issues are different, that the relationships are different, and that they may think they're going up there for a particular reason, but I'm not sure it's possible to predict how someone will judge 5 years, 10 years,
Kathy,
20 years.
Judge Kahn, do you think that we are past the days, and again, I know when you started practicing back in the 1950s and then in the 60s, we saw some very diverse courts and what some people would call today more liberal courts, but we really are past the day and age where a conservative president or a so-called liberal president is going to nominate someone who is anything less than pretty ideologically pure according to their party. What do you think?
Well, people change. Justice Souter was supposed to be conservative, but when he was exposed to some of these issues, he moved to the left. And even if you're ideologically conservative, once you get on the court, you may move to the left. So, and vice versa. As the professor said, Sotomayor has shown indications of moving to the center. And Justice Kagan is renowned for being a person who likes to solve conflicts rather than escalate them, and she may move more to the center. And I can tell you from being a judge myself, you tend to move to the center when you're in the judiciary.
Mary Catherine, it probably would gladden you if you thought for a moment that Samuel Alito could move more to the center, according to the way you perceive it. But if you were a betting person, you probably wouldn't be betting in that direction.
No, it's interesting. When you talk about left, right, center, I think that it's better to sort of divide things into different categories. You've either got the people who are really strong on individual rights who aren't so strong on individual rights. Now, that may not correlate with what they do with respect to benefiting businesses or benefiting the consumer, the small guy, how easy it is to bring cases in court. People can fall in all different places along those spectrums because they aren't the same spectrum. Right. So I would agree that you really can't say a justice is conservative, a justice is liberal, unless you specify which issue you're talking about. They vote very strongly on First Amendment issues. The entire court tends to be very strong on First Amendment issues, but they don't have the same unity on Fourth Amendment issues at all. And that's one where you consider them more conservative. And they don't offer the same protections under the Fourth Amendment. I agree with you. I'd be very surprised to see anyone in that crowd altering his judicial philosophy to the point that we'd see someone, say, striking down the death penalty or taking some other pro-criminal defendant stance.
Judge, how well do these justices get along? I hear that they get along pretty well. In fact, that's almost always the case. And why should that matter?
I know some of them personally, and they're very fine people. I've met Justice Scalia, and I hear that Justice Ginsburg and he are very good friends and very collegial. The court, when I knew them, was extremely collegial. I don't think you'll see much backbiting. I think you'll see some acidic words in a dissent occasionally, perhaps from Justice Scalia and perhaps from Justice Thomas. But that's to be expected, and that's healthy.
And who's filling John Paul Stevens' role on the court if such a thing is possible? Again, he was the liberal standard bearer of, if not the last generation, certainly the last decade. Is that Stephen Breyer?
I think you can say it is Stephen Breyer. He's a man of great intellect, and he can carry that load well.
All right, folks, when we come back, we're going to take a look at some of these so-called blockbuster cases. Can the government put a tracking device on your car without a warrant once you're admitted to jail? Can they strip search you regardless of the charge? And are the FCC standards for indecency too vague? We'll be back in just a moment.
This week's American Law Journal has been made possible in part by Blank Rome, providing strategic advice for employers in today's workplace. King Spry, serving its Pennsylvania clients in family law, business, personal injury, and school law for over 30 years. BADEY, SLOAN, and DIGENOVA, personal attention for those hurt at work or suffering from serious injury. LEVENTHAL, SUTTON, and GORNSTEIN, we have your Social Security disability case covered. Martin Banks, we wrote the book on workers' comp law. EINHORN Harris, a long-standing community law firm with the largest family law practice in New Jersey. Polanski & Polanski, former U.S. government counsel representing those seeking Social Security disability benefits. Hahalis & Kanoupas, representing employees wronged at work. Scheller PC, protecting consumer rights since 1977. And The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.
We're talking about the first Monday in October, and historically, that is the day the Supreme Court comes back to work, or as one of our friends calls them, the Supremes. Mike Trackman was on the show last year. And all 9 justices are back at work today, and a very busy term ahead of them. But let's take a quick look at what they decided last term. 2 big cases. One was Snyder v. Phelps, and the other one was Schwarzenegger. Mary Catherine, again, as a member of the, as a staff attorney with the ACLU, what was the import of that Snyder case? Big First Amendment case.
Well, it meant a lot to a lot of people, but I have to say that no one was surprised at the outcome. And
give the fact pattern for the people.
Sure. Snyder v. Phelps was a case brought by the father of a soldier killed in the service. And what happened at that soldier's funeral is something that's been happening at a lot of soldiers' funerals lately, which is the Westboro Baptist Church, a very anti-homosexual Christian group from Kansas, picketed outside the funeral. Now, the father didn't see the pickets because there were people standing in the way, but he did watch the news later, and he went to the group's website. And the signs, the things they posted on the website were very insulting. I mean, not only are they virulently anti-gay, but they direct that very much at the families of the soldiers, because their whole theory is that our wars are a punishment from God for the country tolerating homosexuality, and that therefore any soldier who is fighting in those wars is supporting homosexuality, and they'll say your son is gay, your son is in hell, your son... Terrible things, terrible things. And the question was, they didn't disrupt the funeral. They were, I think it was 500 or 1,000 feet away, as the local police had instructed them to be. But clearly that's very upsetting. And the question in Snyder v. Phelps was whether Mr. Snyder could bring a tort claim for intentional interference with, intentional infliction of emotional distress. Because of the horrible things that they said about him and his family.
And the Supreme Court said no.
And the Supreme Court said no. The Supreme Court said, you know, these people are protesting on a public place, in a place they have a right to be. They're following the rules. And this, you know, Mr. Snyder's claim would have had some legs if the things they had said about his family and his son would have been taken seriously by anybody on earth. Interesting.
Did the ACLU file an amicus brief in that case?
Yes, we did.
I'm not surprised. I'm not surprised. You're not surprised, Mike Norman, are you?
No, and I think it's a clear signal that this court, by a large majority in a whole range of First Amendment contexts, commercial speech, speech on matters of public concern, like in Snyder versus Phelps, and then a narrow majority of the court in campaign finance cases, is prepared to uphold a very robust, widespread view of the right of freedom of speech.
Right. And Steve Scheller, you'd say that that's a little too broad when it comes to corporations, equating the ability to spend money or money with First Amendment rights.
Yeah, and I don't see spending money in the same class as First Amendment rights of protest, although personally, you know, I think the conduct of the demonstrators was abhorrent, but we've always had that, and that's part of our life. But the difference with money is money buys elections, and when the very wealthy don't disclose who they are, or when they are using their money for in a manner which is not balanced, at least in some respects, there's got to be fairness. It's something that's always been part of our country in terms of money and elections. And I think that was the dividing point for me in that case to a substantial degree.
And in fact, the court just a year or two before had expressly recognized that corporate money buys elections when it held that a West Virginia Supreme Court justice who had been elected through an extraordinary expenditure, overwhelming expenditure by a company whose case was coming before the court, that he should have taken himself off of that case when it came before the court, and reversed the decision of that court because he didn't. And so we have this very strong statement by the Supreme Court that in fact money can buy elections, and you need to protect against that in some fashions, but apparently not by putting any limits on campaign finance.
And Mike Moreland, real quickly, the Schwarzenegger case, why was that important from the last term?
Well, it involved a California statute that restricted sale of violent video games to minors, and there was a challenge to the statute brought by a group of merchants who sell such video games, and the court ruled, again by a fairly wide margin, with Justice Scalia writing for the majority, that the statute impermissibly restricted freedom of speech, and there was a concurrence by Justice Alito and the Chief Justice that was on slightly narrower grounds, and then interestingly a dissent from Justice Breyer and Justice Thomas on quite different grounds each.
Yes.
But nonetheless, again, a very large majority of the court once again upholding a robust understanding of free speech.
Let's look at this new term, some really interesting cases, and the first one we want to take a look at is United States versus Jones. And the question is, can the government place a GPS tracking device on your car without a warrant? Can they do that, Mary Catherine?
Well, the courts are split on that, and there is some precedent from the court saying there's an older case a number of years ago about police putting a beeper on a suspect's car and then following that car around. But GPS is different. I mean, and it's not just a little different. It's not different by degrees. It's a different world. If the police can put GPS devices on any car, and by the way, the question isn't whether they can put a device on your car. The question is whether they can put a device on your car without showing some reason to think you're a criminal.
Right.
And if we're at the day when the police can track anybody's car without any kind of standard governing that, we truly have gone over the edge into an authoritarian situation.
Judge, your thought, your take on this case.
The cases are a little more complex than that. In the Jones case, on some occasions the police put the GPS device on the car when it was in a public place. But on other occasions, at 4 or 5 in the morning, they snuck into Jones's driveway and put the beeper, the GPS device on in that way. And I think that Mary Catherine is right. We can't have that kind of stuff going on. It's easy enough to get a warrant in a situation where you know somebody is buying fertilizer to nourish marijuana crops, and no reason why a warrant couldn't have been gotten there. Very easy to do, and then there's no problem with it.
But as you heard Mary Catherine say earlier in the program, this court, the way it's constituted right now, has given wider latitude to governmental authority in Fourth Amendment cases. I'm going to put you on the spot, Judge. Which way do you think they're going to go here?
I think that the Supreme Court is a line-drawing court. They draw lines that govern our conduct and govern the conduct of the people that govern us, and this is beyond the pale. I think that they're going to strike down the conviction of Jones and sustain the acquittal of the defendant in the D.C. Circuit case.
All right, speaking beyond the pale, some might feel that this case is beyond the pale. Florence versus the Board of Chosen Freeholders of the County of Burlington out of the state of New Jersey. And the question is whether the Fourth Amendment permits a jail to conduct a suspicionless strip search whenever an individual is arrested, including for minor offenses. Okay, who's going to take up the government side in this conversation? I don't hear any takers. Well, we're going to go back to moot court, Mike. Okay. And I'm going to. What is the government's argument here? Why do they need to strip search? And there were plenty of amicus curiae briefs here, where plenty of jailing institutions, if you will, jail institutions, city governments, etc., have all said yes, this is necessary.
The government really has two arguments in these cases. The first is that the Fourth Amendment doesn't even apply in the prison context at all, really. And the second is that even if it does apply, it's reasonable for prison authorities in the name of institutional safety to conduct so-called strip searches. On the facts, also the two New Jersey counties here are also arguing that the so-called strip searches are really just a requirement that the prisoners strip and take a shower and then undergo a search before being admitted into the prison population. Mm-hmm. And the fact is that these prisons are extremely dangerous. I mean, the Essex County Prison harbors 1,000 gang members every day, mm-hmm. and the prisons are rightly concerned that if their ability to conduct such searches is removed by this case, that they'll face a real problem.
Mr. Florence was a motorist, and he was brought to both Essex County and Burlington County jails for a traffic offense. I'm pretty sure it was a traffic offense. Correct me if I'm wrong, Judge.
It was a traffic offense.
Okay.
And there was a mistake made. He had actually taken care of it and had a receipt that he had taken care of it. I think the problem with the case is that, of course, jails must be concerned about internal security. But here, in this situation, this shouldn't have happened.
Yeah.
And that's going to be a problem.
Right.
That's going to be a problem, and the Supreme Court has to draw a line. Are they going to protect the institutions when something this wrong happens, or are they going to draw a line and say, you went too far here?
All right, let's go through a couple of these other cases, unfortunately, rather quickly. FCC versus Fox Television Studios. This is about the so-called allegations or claims that the standards that the FCC are enforcing are vague.
Well, I think that this court will care very much about the vagueness issue, and I think that's where it's going to turn. This is different from your usual First Amendment case, right? Because stations are licensed by the FCC, and they're licensed to occupy very special and prime time on our broadcast. But so the court, my prediction is the court would say the FCC can make rules, but it can't make rules that are so vague that you don't know from week to week what's going to be considered indecent.
Hosanna Tabor, that's a favorite case of yours. Why don't you tell us what that case is about quickly?
Well, for decades, the circuit courts of appeal have all held that religious institutions are exempt from the employment anti-discrimination statutes with respect to certain kinds of ministerial employment decisions. This is the first time the Supreme Court has taken a case in which it will clarify if and to what extent religious institutions are exempt from the anti-discrimination statutes.
Okay, and I guess it's a retaliation issue.
ADA retaliation.
Gotcha.
Claim, right.
So if I'm working in a private corporation, I can usually bring a retaliation case, but when you're working for a religious organization, you really...
As a minister.
As a minister, you cannot bring a retaliation case. So this court will have to decide that issue, whether that applies or not. And then this case, Steve, a real important, CompuCredit Corp versus Greenwood. And the issue here is whether claims arising under the Credit Repair Organization Act are subject to arbitration. According to the Act, from what I understand, the government wanted to give people the ability to file a lawsuit against organizations that were there to help them repair credit. That's what the Act says. But apparently, they're trying to bind people with arbitration agreements. I know you find arbitration agreements usually, not always, to be repugnant. What about this case?
Yeah, and it's the conflict between the legislature just saying you have the right and another act, the Arbitration Act, which said courts have interpreted as giving the right to compel arbitration in agreements. It's a conflict there. My own view of that is basically I have been involved in instances where arbitration can be okay and where it isn't. And I think in the credit area, I would be very hesitant to require a citizen to accept arbitration in the broad term. What kind of arbitration? Who's paying for it? I think that's a bad situation, particularly when the legislature has said you should have the right to sue.
But maybe the hallmark of this case is, can people be compelled to arbitrate by contract?
Yeah, and I think that that's a mistake, and I would hope the Supreme Court would realize that this is, again, the situation not of businesses so much in the sense, but businesses trying to control the ordinary citizen and possibly making it much more difficult for them to get a fair hearing.
All right, quickly, very, very quickly, but is this a blockbuster term, or do they always say that? Do we always say that every term? This is a blockbuster term. Big cases. Why is it or not?
As it's lined up now, not really. But if the Fisher versus University of Texas affirmative action case is granted cert on, and of course if the healthcare mandate issue comes up before the court this term, then we could very well by June have 2 blockbuster decisions from the court.
Steve, you think this is a big term?
It could be. I think, frankly, I'm concerned that in this coming election is going to determine whether the Supreme Court is going to be a court that we can depend upon to protect the middle class or the ordinary citizen, the way I look at things. I have a feeling if it goes against the Democrats, based on the candidates I see coming down the pipeline for the Republicans. It hasn't been talked about much in this election and this campaign, but I think that's a real danger to our democracy and to the long-range effects of what it will do to the Supreme Court.
Right. Sadly, the Supreme Court isn't talked enough about prior to a presidential election.
I think it needs to get into this election very thoroughly, because we, frankly, do not need to make things more difficult for the ordinary citizen. And I have a feeling a court that will make it more difficult will probably be a court appointed by a Republican president, at least from the candidates I see them running.
Mary Catherine, is this a blockbuster term? Especially, let's say they also hear the Prop 8 case. Then does that put it into blockbuster terms?
Well, that gets it into a much higher profile term. I'd have told you this past term, the 2010-2011 term, was a blockbuster term. A lot of very important cases.
Mm-hmm. And Judge?
I don't think it is a blockbuster term. I think the Second Circuit was right that the FCC's regulations are vague, are void for vagueness. I think the strip search case is pretty clear that something has to be done there. I think the Jones case, where you put the GPS in, is pretty clear that you can't do that. I think this is going to be a run-of-the-mill term.
I want to thank my guests, Mary Catherine Roper with the ACLU in Philadelphia, Pennsylvania, the Honorable Edward Kahn, who sat for decades as a judge in the Lehigh Valley Federal Court, Michael Moreland joining us tonight from Villanova School of Law, and Stephen Scheller with Scheller PC in Philadelphia. Check us out every Monday night. Go to our website, lawjournaltv.com. Check us out on Facebook. And for all of us here at the American Law Journal, thank you for joining us. Until next Monday, case closed.
This week's American Law Journal has been made possible in part by Blank Rome, providing strategic advice for employers in today's workplace. King Spry, serving its Pennsylvania clients in family law, business, personal injury, and school law for over 30 years. BADEY, SLOAN, and DIGENOVA, personal attention for those hurt at work or suffering from serious injury. LEVENTHAL, SUTTON, and GORNSTEIN. We have your Social Security disability case covered. Martin Banks, we wrote the book on workers' comp law. EINHORN Harris, a long-standing community law firm with the largest family law practice in New Jersey. Polanski and Polanski, former U.S. government counsel, representing those seeking Social Security disability benefits. Hahalis and Kanoupas, representing employees wronged at work. Scheller PC, protecting consumer rights since 1977. And The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.